All right. Thank you, everybody, for being here this evening. It's March 17th, 2026, and we'll go ahead and kick off tonight's work session. The only action item we've got on the work session agenda this evening is an interview for the town attorney. We've got Mr. Carl Cumley with the firm Dietz and Davis here with us this evening. Just to give everybody some quick background, the town board directed staff to open applications for a town attorney on January 27th, 2026. Myself and Trustee Dietz, as well as part of town staff, took part in a phone interview, and tonight we'll conclude those interviews. So we'll go ahead and get started here. I think we'll kick off by having just a quick round of introductions, if that's all right with everybody. Ms. Clerk, if you want to start.
I'm Hannah Hill, the town clerk for the town of Wellington.
Good evening, Patty Garcia, town administrator.
Sherelle Teets, town trustee.
And I'm Ed Cannon, town trustee.
Brian Mason, Mayor Pro Tem.
Rebecca Daly, trustee.
Dave Wiegand, trustee.
Lowry Moyer, trustee.
Awesome. So, Carl, we've got about 16 questions for you here this evening, but if you want to maybe just come up and give a quick introduction as far as your firm goes and yourself. So.
Thank you, Mayor Pro Tem. My name is Carl Cumley. I'm an attorney with the Boulder law firm of Dietz and Davis. There are 20 lawyers in our firm. 4 of them are of counsel, meaning lawyers that have a contractual arrangement with our law firm. We have about 3, almost 4 associate attorneys. And I say almost because one of them just made partner. And then 14 shareholders who are the actual owners of the firm. I'm one of those. I've been at Dietz and Davis since 1997. I grew up in an agricultural town in Northern California, went to school in the Bay Area and in Sacramento, California, came here in 1981 at the request of, or not really the request, at the strong suggestion of my water law professor in law school, who was a 1938 University of Colorado law grad, and was very close to Byron White. And so that's my 6 degrees of separation from Byron White, which I think every lawyer in Colorado has 6 degrees of separation from every other lawyer. So my practice when I came here and still is primarily focused on water law. But over the last 10 years, I have taken on a number of municipal and quasi-municipal clients. I do a lot of work for Pueblo West Metropolitan District, which serves about 40,000 water customers north and west of the town of Pueblo, city of Pueblo. Over the years, I've worked for a large number of Colorado municipalities, both home rule and statutory. And the way that the laws are set up in Colorado, there actually is a lot of similarity between special districts, which are creatures of statute, and statutory municipalities. Both are subject to CORA, both are subject to open meetings law. There are differences in the breadth of services that they may offer. But I've been doing this kind of law now for a while. I enjoy it a lot. I enjoy establishing personal relationships with municipal staff as well as board members. And I'm probably working for another 7 or 8 years myself. And at that point, I probably will slow down a little bit, but hopefully not too much more than that. My wife and I live in Broomfield, just over the Boulder County line. And that's about it. Why don't I use that as a jumping off place, and please feel free to ask anything you care to.
Well, thank you, Mr. Cumley. Really appreciate the introduction on that. I think what we'll do here is we'll just go around in the same format that we've done for the past interviews and just have each of the trustees ask questions in a clockwise fashion. So I'll go ahead and kick it off, I suppose. Mr. Comley, what interests you about serving as town attorney for the town of Wellington, and what do you see as the most important role of a town attorney in a growing community?
Of experience when I was going to law school in Sacramento with California government. I also clerked, had a fellowship in the House of Representatives, so I've worked on Capitol Hill. I would say, very familiar with legislative processes. I'm also very interested in how decisions get made, what kind of values people bring to their decision making, how they reflect the values of their constituents, and then how boards and legislatures and Congress either do or do not work together to solve problems. To me, that's very fascinating. So with respect to Colorado municipalities, having been here a good long time, I'm pretty familiar with how the state works. My son and my wife both went to CSU, so I have a little bit of familiarity with northern Colorado, but I've done work really in all four corners of the state. I spent a fair amount of time in southern Colorado, not only for work, but also I serve on a nonprofit board down in Cortez, which is in the very furthest southwest corner of the state. Very interested in resource management issues. Those have always been important to me and continue to be. And also interested in the combination of land use, water, and transportation, as well as energy. So those are the areas in which I have the greatest experience, but I do have experience in planning and zoning. I do not have experience with law enforcement. However, one of the metro districts that I represent does have responsibility for fire. So fire and ambulance are both services with which I have some experience too.
Thank you. Appreciate it.
That's a good segue into our next question. It's regarding land use, including zoning, annexation, subdivision, development agreements. What is your experience with those and what successes stand out?
On all sides of subdivision improvements agreements, negotiating them. I've done that on behalf of developer clients over the years, working with the state engineer's office to assure adequacy of water supply, and working with county planning and zoning, which is not something that you're subject to in a home rule municipality, but a lot of experience there, experience in working with FEMA on flood maps, working with all kinds of road and ditch easements, extensive work on both road and ditch easements, property line litigation, quiet title actions. Gosh, I hardly know where to start, but also a lot of work with the developer community to try to help them comply with local government requirements. So I would say kind of the broad swath of planning and zoning.
Great. We are a statutory town. And then how about anything related to PUD?
I'm sorry?
PUD, planned unit.
Planned unit developments. I've done several. I've done several, particularly with NUPUDs, non-urban planned unit developments, where there's large provision for open space and cluster housing. Have also worked with more dissociated developments with the houses spread over a larger area, but definitely a lot of work in planning with water and wastewater in particular. So I would say those are my skills and experiences.
How would you advise, sorry.
Oh.
How would you advise the planning commission and trustees in a quasi judicial land use hearing to ensure compliance with Colorado law and limit legal exposure?
That's a great question. A number of things just sort of jump to mind. Number one, since you said a quasi-adjudicative or quasi-judicial
Right.
hearing, while the rules of evidence don't apply per se, all of the trustees and staff need to have a good working knowledge of their own ordinances and how their ordinances are going to operate with the developer. Having experienced staff work on those issues is an absolute treasure. To have people who have supervised the process, have really a good working relationship, professional working relationship with the developer community, know the questions that need to be asked and drill down on those. For the trustees, I think it's really important to maintain not just the appearance of objectivity, but to really come to every adjudicative hearing with a judicial mindset that you are dealing with people's property rights, their constitutional rights. That's awfully important stuff. And people will have invested their money, their shareholders' money, and they're looking for a return on that. That's appropriate. Nothing wrong with that at all. However, the community that you represent has needs that may or may not be in lockstep. And what you need to do and what your planning commission needs to do is to come to those decisions with a vision for the future, with a strong awareness of how this new development is going to fit in with the community and what it's going to do to build community. And I think those are all very important considerations. As far as my legal advice, run tight hearings. That you'd be really surprised, but staying on task is something that is important to your constituents. It's important to the people for whom you're going to be making the decision. And hopefully it brings about respect for the process, and that at the end of the day, whether the decision is popular with any particular part of the community or not, everybody who looks at the process agrees that it was fair. And I think that is really the touchstone of what you want to accomplish. So I think those are my just off the cuff kind of thoughts in response to that question.
Thank you.
You bet.
All right. What's your approach to drafting and reviewing ordinances, resolutions, municipal code, and intergovernmental agreements for clarity and defensibility?
Boy, let me try to unpack those because you gave me a whole bunch. With ordinances, one of the important things is to understand the entire, I'll call it a statutory scheme, but the organizational scheme behind the ordinances, and to determine if there is anything in your code which actually isn't there and should be. So one of the first things is going to be taking a look and trying to make sure that you have all of the tools in your toolkit to deal with the situations that you're likely to to confront in those administrative hearings where you're making decisions relative to people's property rights. So that's on the ordinances. With regard to drafting intergovernmental agreements, it's always helpful to have a good and positive relationship with the people who are on the other side of the table. That's something that I believe that lawyers can be collegial while being fervent advocates for their clients. So I believe that building those relationships countywide with special districts, obviously representing a number of special districts, I have understanding of where the special districts may be coming from. So having those personal relationships, I think, is very important. As far as my drafting, if I know generally where we want to go with an agreement, I'll generate bullet points. That's where I always start with a new document. I'll then go over the bullet points with staff and make sure that either, is there anything I'm missing? Is there anything that I've put in my list of bullet points where staff is going, now, why did you do that? What are you trying to do here? To make sure that we have that collegial exchange of information. I see your town attorney as obviously an advocate for the town, but also a member of your team. And I would hope that with every department director, that we build a collegial relationship. And so when I get around to drafting the IGAs, when I get around to drafting subdivision improvement agreements, I actually have a good idea of how this is going to fit with everything else that is in our toolkit. Because a subdivision agreement, subdivision improvements agreement, really is part of your toolkit because it's going to govern a long portion of that property use until the development is completely built out. So you're going to have ongoing relations with those developers, and that's another place where having collegial relationships is actually pretty important. I know I missed a couple because we ran over ordinances and IGAs.
I think we hit on most of them. Ordinances, resolutions, municipal code, maybe, and then the intergovernmental agreements. And then it was for clarity and defensibility.
Now that's a great, I'm not sure I captured that on the first go round. As far as defensibility, having a really good familiarity with Colorado statutes is very important. Keeping up on current case law is going to be really important in terms of defensibility. I had an oral argument in the Court of Appeals in early January, and we came up with a very important case the day before our oral argument. And it's only because we went back and examined the case law after we had written all of our briefs for the court and updated them. And so a knowledge of what is going on in the common law, the court-made law, is also really important because that does change over time. Obviously, it's also important for any municipal entity in Colorado to have a decent working knowledge of Tabor and the restrictions that come with Tabor. In terms of elections as well as budgeting, what you can do and can't do in terms of raising revenue. And so all of those are important things to be aware of. You bet.
Okay, I feel pretty privileged because I got to ask a lot of these questions in our over the phone interview. But how would you advise a municipality on transitioning from statutory to home rule And what key legal, procedural, or governance issues should be considered when doing so?
I will be completely honest with you. I have worked for many home rule municipalities. I'm certainly familiar with the process generally for obtaining a municipal charter, and to be aware of the fact that with a statutory town, your powers are circumscribed by the statutory framework that the General Assembly has put in place for you. And that's your field of engagement. With a home rule municipality, I think you have to have a certain kind of vision of what you want your charter to look like and how you see the municipality growing over time. Do you want all of the powers that are set out in Article 20 of the Constitution? Or do you want to pick and choose, figuring that you can add some of those later? I think in making the transition, which is part of the question you asked, you're really going to need to build a timeline and put the timeline's obviously going to be driven by the constitutional requirements for developing a charter, but you're also going to need to plan the transition from statutory to home rule, what that's going to look like, and what the town governance is going to look like once you've actually made the transition. So there is a lot packaged up in all of that. I think one of the first questions is, do you want to become a home rule municipality? And if so, why? What are your objectives in doing that? Because the practice of law is very much about implementing the client's desires. So with the board as the client, just want to make really sure that there is a shared vision of where we're going and how we're going to get there, so that we really can do a good job of drafting a charter. We're going to look at lots of examples from around the state. Bigger municipalities, I'm certainly very familiar with City of Boulder's charter because I was outside counsel for them from 1981 until they took my job in-house in 2005. So a long time working with that municipal charter. But I've also seen charters and worked with charters for Aspen and for Trinidad and a number of municipalities around the state. I think most of them are listed in my CV that I've done work for. And most of them are home rule municipalities. So.
Perfect. Thank you.
You bet.
Counselor, welcome.
Thank you, Mr. Trustee.
Tell us about your experience advising on Tabor, taxation, and/or fiscal issues in Colorado.
I am not the best person in our firm on Tabor issues. My law partner, Carolyn Steffel, with whom I work very closely, is our Tabor wonk. I do work closely with our director of finance at Pueblo West. We confront Tabor questions regularly. We also confront Tabor questions when we go to the voters and we're asking for a continuation of taxes or an increase in mill levy. So we work really hard, and Tabor is not always an easy statute to interpret. So if I don't know, and if Carolyn doesn't know, we probably will at least investigate the matter, talking with some of our friends at CML to get their legal perspective. There are also listservs of municipal attorneys, and we tend to use those too. But when you use a listserv, as a lawyer, you've got to be really careful because you don't take off your obligation to maintain client confidentiality. So You have to tailor the questions that you ask on the listserv pretty carefully and make sure that you're asking generic questions and not revealing client confidences. Those are the tools that I would ordinarily use. And I'm trying to think of what else. Obviously, the place where your constituents run into Tabor are at election time. And so making very sure that you meet all of the statutory deadlines for elections becomes terribly important. And that's another part of building confidence in the electorate in how the government is running, and confidence that you know what you're doing.
Can I ask a follow-up question to that? Since the cancellation of the Gallagher Amendment and its impact on Tabor throughout Colorado's history, what is your experience with what municipalities are going through in the absence of the Gallagher Amendment?
We actually spent a lot of time going through the calculation of some of our limits on what we can do in terms of raising revenue. And for Pueblo West, that became something that we needed to look at really carefully. So like any other lawyer, I'm going to go back to the statute, take a look at, and also there are some good law review articles out right now on what unplugging Gallagher means to Tabor. But that is not my area of absolute expertise. So I'm going to reach out to my law partners to help me with that. And I'm going to be honest with you that I'm doing that. You bet.
All right. Describe your experience negotiating collaborative agreements with public or private entities for shared water, wastewater, or utility-related services or infrastructure, and how did you address governance, cost sharing, and performance obligations?
That one's a little more in my wheelhouse than the Tabor question. For example, the client that I represent, Pueblo West, is one of the 6 major municipal water providers on the Arkansas River, along with City of Aurora, City of Colorado Springs, City of Pueblo, Southeastern Water Conservancy District, and Town of Fountain. We have several IGAs that we've put together. 6-party IGAs are not easy to negotiate, but they can be done. They just generally take a lot longer because you've got various communities of interest. And particularly when you have disparities in the water arena between parties that want to export water out of your basin, which is City of Aurora for us. Colorado Springs is sort of the 600-pound gorilla in our work there. But we have a really good collaborative relationship with both Colorado Springs and City of Pueblo. We also joined together in litigation. Right now, I'm in some water court litigation with Pueblo West, Florence, Town of Florence, City of Canyon City. It's actually City of Florence now. City of Canyon City, and 2 other, Monticello and 1 other small municipality. And we got statements of opposition from both the state engineer's office and Town of Penrose. So we've got a large community of interest where the parties need to put together joint, what are called common interest agreements in order to protect information from discovery in water court proceedings, and also working prospectively to develop the water court decree that's actually going to be entered by the referee and the water judge eventually. With regard to wastewater, the first question is going to be who's upstream and who's downstream. And what does that look like in terms of your obligation to the Water Quality Control Commission to meet stream standards and classifications, to take a look at cost sharing for wastewater treatment, which is a really big deal, and one that we've struggled with as well. With regard to provision of water, source water protection is a very big deal. I believe that a good amount of your water supply comes from federal project water, as well as from water rights that have already been adjudicated, but to also have a good sense of who your other parties that you're going to be meeting in water court are going to be, and then again, building those collaborative, or if not collaborative, at least collegial relationships to try to minimize process cost, identify issues quickly, and move toward resolving them.
Thank you. Appreciate that.
You bet.
On a similar subject of water rights and those, what's your experience in negotiating and review of contracts related to water or wastewater infrastructure projects?
Obviously, the most important thing on the front end is wrapping your arms around what the needs are and what it's going to cost to meet them. And once you do that, if you're going to go to a bond election, for example, making provision for working with bond counsel, if in fact you would use bond counsel, which I would strongly suggest, in order to achieve the best rate in terms of the amount of money that the town is going to be paying over time, making sure that you're getting all of the infrastructure that you need. And if you have to do phase development, what does that look like and how are you funding it? Are you at risk because your interest rate may creep up? And you'll find that even though you know what the capital cost is, your actual monetary cost over time may end up being substantially more if you don't actually have someone to be able to advise you on what's going on in the bond market, how to minimize your exposure over time. I think those are my my most important considerations. Obviously, taking a look at what your community can bear too. You need to have some sense of not only the statutory requirements in terms of what you need to get to in terms of your effluent constituents, but what your town can afford, what grants are available from the state, both from CDPHE and also from the Colorado, I'm trying to remember the name of the organization, but it's the Colorado Water Resource Development and Energy Authority. There's an energy component to that as well. So having a good idea of where to go for funding at the state level, and then if you have to go to the bond market, making sure that, or if you're going to do it, that you're going to be cash funding it over time, how you would go about setting that up, because I think that gets a little trickier. So,
Thank you.
You bet.
In a municipality, sorry about that. If a municipality is considering a metro district in their town, what key legal, financial, and governance issues should be considered before approving a metro district?
Well, the first question is, what is the Metropolitan District going to do? There are about 10 to 12 different subject matter areas that metropolitan districts are allowed to engage in by Title 32 of CRS. And so I think if you're going to create a metro district, obviously that goes through a process through district court. You need to know what the boundaries are of the district, what the services that are going to be provided are, how the district is going to provide those services, and then what the interface is going to be between the metropolitan district and either the statutory or home rule municipality. You bet.
All right. So what is your experience with public records requests, and how do you balance the statutory transparency requirements with privacy protection?
Great question. As you probably know, the municipal clerk's dream bill got PI'd again this last, postponed indefinitely in the last session. So we haven't got Cora relief, largely because the journalism community in the state likes the way that Cora is put together right now. We have had for several of my clients, we have had a relatively new development where businesses are employing search firms to generate Cora requests on sometimes a daily basis in order to learn as much as they can, not only about the local government with whom they're dealing, but also what the retail environment is, where the local government is sourcing its equipment, its fleet, where the local government is going to obtain a number of other services. And so you have people filing Cora requests in order to learn as much as they can to shape their bids in response to a municipal RFQ or RFP. And that has turned into a major burden for our municipal clerks. There are a couple of things to remember, though, about Cora. I'm sure your clerk gets regular Cora requests, which are actually questions that they want local government to answer for them. That's not what Cora does. Cora is a records statute, and what has to be provided are records. Now, records are very broadly defined. They're everything from voicemails to Post-it notes to finalized reports of staff. So there are a lot of different items of communication that can fall under Cora. But we do work really hard, and we work really closely with clerks to make sure that a Cora request, number one, is within the four corners of the Act. Number two, if we need to ask for the enlargement of time that's available under Cora from 3 days until 10, and those are business days, that's very important as well. We try not to use that as a matter of rote, but only to ask for that extension where we really need it. But that also means that you need to have an information system that allows you to access documents pretty quickly. And that gets into two other things that we deal with a lot, which is the machine searchability of records and also records retention. And so both of those are issues that we touch on with Cora on a pretty regular basis. You bet.
I apologize. Municipal attorneys are often asked to provide guidance on personnel matters that can involve legal policy and risk management considerations. How do you approach providing legal counsel on sensitive personnel issues while ensuring the town complies with employment laws and maintains appropriate confidentiality?
We work really closely with our senior HR officer to make sure that, number one, we have a personnel manual that falls within all of the requirements of Colorado law, that we have a process for review of employees on a regular basis, for a well-identified personnel system to give employees the uncomfortable news often that their performance is not meeting requirements, to put them on a PIP, a professional improvement plan, if necessary, revisiting their performance and making sure that if we have put them on a performance plan, that we can document either compliance with the plan or failure to meet expectations. We do have at our firm 2 attorneys, very outstanding lawyers, who are nothing but employment law attorneys, and I am not above putting my HR folks directly in touch with them if we have a question that's a little bit naughty, Knotty, not Naughty. So those are some of the kind of guidelines that I use. We do run into substance abuse issues on a fairly regular basis. It's important for the town to have, if not a policy, an awareness of what's permissible under Colorado law. We recently advised one of our clients about how to handle substance issues in a pretty thorough way. So that is something that we deal with on an ongoing basis. But I think that making sure that the employees are well aware of what their rights are and then what's expected of them, that's kind of ground zero. Yeah. Sorry, most welcome. I know I keep reflexively saying you bet, but I really mean that as thank you for good questions, and I appreciate them.
Thanks for clarifying. You bet. So, Mr. Coomley, municipal attorneys playing an important role in getting over a cold. Municipal attorneys play an important role in helping elected officials and staff negotiate and navigate potential conflicts of interest. Can you provide an example or 2 of when you had to advise a government body or staff member on a conflict of interest? What steps do you recommend, and how did you ensure transparency and legal compliance?
Fair amount of experience. Every time we onboard new members to a board, I think it's important to provide them with written materials about conflicts of interest. There are several conflict of interest statutes in Colorado, and they are not all alike. I believe that we talked about trust. Conflicts of interest are the enemy of trust, and they are sometimes the fatal enemy of trust. It's folksy to say that if it doesn't smell right, it probably isn't right. But I think when people start asking the question about doesn't so-and-so have a conflict of interest, the trust horse is almost out of the barn by that point. So I think education on the front end, both for staff and for trustees, is really important. I have in the past, and I think it's sometimes helpful, done a little conflict of interest 101 kind of training. I believe strongly that an attorney for local government can be an educational resource for staff and for the board. So I'm a big one about helping staff learn how to write resolutions on their own, helping staff identify conflicts of interest, making sure that the board is aware of conflicts of interest and how they arise, and whether they may need reporting to the Secretary of State. Certain conflicts of interest do require reporting to the Secretary of State. Most of them do not. I believe it is important to be proactive in addressing conflicts. And while I cannot give legal advice to a single board member, if a board member wants to communicate a concern about a conflict of interest, I certainly will work with them to put some meat on those bones and make sure that we get good information back to the trustee about how the statutory framework is likely to treat those conflicts, whether they need to be disclosed to the Secretary of State, or more importantly, whether they need to be disclosed to the town or the district, and how you're going to disclose them and when you are going to recuse yourself. Because you build a lot of trust when you say, you know, I don't think it's a conflict of interest, but I want all of my constituents to be really comfortable that my involvement or my contact is not going to result in a situation where you might think I'm personally profiting. So I'm going to recuse myself. I do not think it's a dereliction of duty for a trustee to say, I'm going to be careful and I'm going to recuse. I think it is in the best interest of local government because it builds the trust. So did I answer all of that question?
You certainly did. Thank you.
Okay, thank you.
3 more to go, almost done.
Okay.
Let's see. How do you stay up to date on new laws and case rulings, and how would you communicate those changes to the board and staff?
We do it a lot. We're a very collegial law firm, so there are emails that go back and forth in our shop a lot about, have you seen this bill? We also work pretty closely with our legislative consultants who have a good idea of what we do and how we do it. So they can report to us. They often come back to us and say, and we have either weekly or biweekly meetings when the General Assembly is in session, so January to early May, where we see a number of bills. There are, 800 bills that have been dropped in the hopper so far this session. We don't want to, need to, and don't read all 800 bills, but for the 24 or 36 that may affect our client, yes, we will look at those. We're not going to spend a lot of time on it because the bill may not look, when the governor gets around to signing it, may not look the same way that it did in February. But we certainly will, if we think that there's something that's going to directly impact an interest of our client, we'll flag that as early as we possibly can. If there's a need, we may ask you to testify before the General Assembly. It's powerful when a local governmental official goes into a House or Senate committee room and says, here's what you're doing to us, and this is not helpful, and here's why it's not helpful. Or this is something we truly need, and we just can't wait any longer. I think that's powerful testimony, utterly appropriate, and I've seen it change the dynamic in a committee room and seen a bill get delayed in being reported out so that it didn't actually make it off of the floor before the end of the session. So I do think that engagement throughout the legislative year, or 6 months, is important, and so the communication starts then. It may also come up that if the local government is moving into a new area of activity that they've not been involved in the past, that we probably need to do a little bit of taking a look at the playing field and make sure that we identify statutes with which we're going to have to comply that we haven't had to before, and to do some discussion and advice about what these new policies are, or even if they're old policies, ones with which we haven't had to deal before, and planning to meet them. So
Wonderful. Thank you.
you bet. Thank you.
How do you balance your role and obligations with budgetary constraints of a small municipality?
I'm sorry, say that one more time.
How do you balance your role and obligations with the budgetary constraints of a small municipality?
Great question. You know, some municipalities, paying the lawyer is not a big deal. They're used to seeing budgets with attorney hourly rates far in excess of ours. Bond counsel is one of those. Those folks have hourly rates up in the stratosphere, but they also incur a lot of risk. So there is some quid pro quo there. I think it's important to know, and one of the questions that I would have for you is, what is your expectation of a legal budget? Are you looking at something that's going to be in the 5-digit per year range or 6-digit per year range? And I expect that your manager will be looking over our billing statements, will be asking us questions. Why on earth did you spend 5.5 hours on something when it seems to me you could have done it in 2? We invite those questions. You always get to question our bills. We try to work really hard to stay within client expectations of what we're going to be doing. However, if we see litigation as always kind of the specter that haunts us as far as budgets, because once you're actually in litigation, you've got obligations to the court in terms of discovery, in terms of preparing for trial, and those things can be ruinously expensive. It is very hard to go to district court anymore for much less than $75,000 to $100,000 for a major case. And it can get a lot worse than that very quickly. If you've got multi-party litigation where there are multiple millions and sometimes billions of dollars on the table, those are fights where we really need to take a look and say, what's important to us? What do we need to have out of this litigation? And I'm a big believer that a settlement you can live with is a whole lot better than going to trial and maybe not getting the result you thought was a slam dunk. So I like to be more careful, mostly because in the last analysis, those are public funds that we're playing with. It's not a board of directors of a private corporation.
Thank you.
How do you approach advising elected officials on procedural matters, particularly when they are competing opinions and political tensions?
The first thing I would do is I would say that, and one of the questions that I have is, what manual do you use in terms of parliamentary procedure? Is it Sturgis? Is it Roberts? Is it something else? There are a couple other new ones out there. Making sure that everyone understands that civility is important in getting the public business done, and that a disagreement on policy does not mean that the person with whom you have the disagreement is morally bankrupt. You can have people that are very, very disparate in political outlook and are working to achieve the same ends, and you can try to resolve those tensions. But I do believe very strongly, particularly with a board of 7 folks, you need to cultivate civility. And that's true. And I've represented local governments as politically diverse as you can possibly imagine. And I have been very lucky in that I have seldom, I won't say never, but I have seldom found myself in a situation where we actually had to adjourn a meeting because the tempers got too hot. But it does happen. And it's important to be able to take a break and say, we'll come back to this issue later in the evening, or we'll table this issue until the next meeting and we'll revisit it then. My experience is that those tensions seem to really fly into high relief when there is a similar set of concerns among your constituents. So I think my practical advice to board members would be talk to your constituents with whom you don't agree. Listen to them. They are part of the folks that are voting for you. They're an important voice in your community, and the product of your decisions is going to affect both the folks that voted for you and the folks that say, I can't stand so-and-so. And so cultivating that mindset of really actively listening to people with whom you don't agree, I think is tremendously important. And I've been practicing law a long time, but I don't have all of the answers to all of the questions, even the legal ones. I have to go back and study occasionally and reread statutes that I've read a bunch of times before because I need to know what a particular clause looks like. I don't think that you as elected officials hurt yourself at all by saying, I will take a closer look. You make some good points. I want to be sensitive to your concerns. And asking people to help you do your homework. But you have, in Wellington, you have a lot of paper that you are dealing with all the time. You are studying all the time. You are trying to make the best decisions you can, sometimes on fairly compressed time schedules. And that's not easy, but it's a whole lot harder when people aren't being civil to each other. So as your attorney, I would probably work pretty hard at trying to keep folks, number one, sticking to process, sticking to issues, and recognizing that just because you're being civil to someone doesn't mean you aren't being a fervent advocate for positions that you believe in.
I really like that answer. What questions do you have for us?
Well, let's start off with the one I touched base on, which is what do you expect to see in terms of a legal budget, and how have you shaped that budget in the past? And an important question, what have prior counsel for you done well, and what might they have done better, so that I have an idea of how I can meet your expectations. If I'm really lucky, how I might exceed your expectations, but at least be aware of them. So a sense of budget, a sense of how you think you might circumscribe or work with that budget, and what we can do really well for you, and what you've seen other lawyers do that you think we might be able to improve on.
I'll start with that response for that first. Oh, I can say is there would be a clear expectation and ample communication and review from the perspective of an administration of our town on if you're on track or anything like that. So you could expect and would expect that kind of communication and oversight. So
good.
No concern there. Something I really appreciate about legal services in the past is ensuring that there is good relationships and participation and advocacy with the staff level to ensure that everything that comes before the board is 100% in line with expectations from staff. That way, it really just has that final review of whether or not it's within our expectations as well. There's not multiple directions of push for any of those items. So I really expect a very concise working relationship from all of our leadership, from our staff perspective with you. And I expect for that to be really forthcoming and an easy relationship. I think that's super important. And then the other thing is you did ask about our procedure in our meetings, and we use Bob's rules of order. So helping with process and procedure is something else that we've appreciated in the past from legal counsel. But mostly that's it. Making sure that resolutions, everything that comes before our board is accurate, concise, and really has the meaning behind what we're trying to accomplish. What I hate and has happened in the past, not in the recent history. I do want to say that just for our previous legal counsel, I was a big fan of, is there would be errors, typos, misinterpreted items that would have to be caught and corrected live during meetings. And that just does not provide the professionalism that I would like to bring to our community. So those are things I haven't appreciated in the past. Thanks.
So as you were talking, I really noticed that you talked a lot about research and education and relationships. And so one of the things that I think I've seen in the past that I wonder how you would handle would be if something came across your desk that was a staff recommendation that you didn't agree with or you didn't see was best for the town. And I'll just use home rule as an example. If you didn't think we were ready, like how would you handle those things that you see as not appropriate for us as a town at that time? And how would you make sure that we had all of the information so that we would be defensible in making our decisions?
I think it's important. Those are great questions. I think it's important to recognize that lawyers are there to advise you on how best to comply with the law. We are not policymakers. That's what folks have elected you to do. We can and should work with you to see to the implementation of policies that you decide. And that really is a very important function for us. You had two other parts to that question, and I want to make sure that I address them as well.
I think the defensibility piece is big for me.
Right.
And so if you saw a staff recommendation coming down that you didn't necessarily think was defensible legally, how would you handle that?
Yeah.
And I mean, in real time in the meetings, whether it was, Board of Adjustments, Planning Commission, Board of Trustees, how would you handle something going a different route than you saw legally it should?
It's hardest to do that if I'm only aware of the issue in the meeting. And this gets into the entire process of putting together an agenda, the draft agenda of what are the items going to be on the agenda. Are we going to have executive session items? If we're going to have executive session, are we going to do them prior to the meeting? Are we going to do them after the meeting? Prior obviously helps you if you have to come out of executive session and actually make a decision on the record, which of course you can't do in an ES. With regard to the way that I like to handle it, if I'm aware of an issue, is you'll probably get a 2-page memorandum from me, never longer than 3 pages, but a 2-page memorandum that says, this issue that you're confronting raises several really thorny legal issues, and we need to be aware of them. Here's what statute requires. Here's what case law says. You're possible courses of action might have you in compliance with case law, but there's a question as to whether you're really complying with statute or vice versa. If we are going into litigation, we will write litigation memos for you that will say, here are the issues. If we're going to be representing you as plaintiff, for example, here are the claims or causes of action that we're going to be pleading to the court. And here's what we have to prove. Here's what we think the other side is going to use as their defenses. Here's how we plan to overcome them. Here's what we don't know and we still have to find out. And if there are pivotal witnesses, identifying them and trying to make a determination as to whether they are going to stick with what we think their stories are or not. That's just ordinary litigation savvy. There's nothing remarkable about that. But it is important that if you are either going to defend litigation or maybe even be an intervener in litigation, if you see that there's something coming down the pike that is CML tells us this is an issue that's going to affect all statutory municipalities, and we take a look at it and say, yikes, for Wellington, that's a pretty big deal. Making sure that we see if we can put together a community of interest, maybe several other statutory municipalities, to put together an amicus brief for the court so that a court has the opportunity to at least consider your legal position and how that might affect you. I think our appellate judges in this state are really awfully good and awfully directed at getting the law right. I think our benches generally are too. The problem with the trial courts is that they have such an outrageously heavy caseload that you often see decisions where I, as an attorney, have strongly suspected the judge handed the case file to one of their judicial clerks and said, here's where I want to get, write it up for me, do the best you can, bring it back to me, and maybe the court signs it without a whole lot of investigation. That's very frustrating for me as a lawyer. And appeals are also expensive. And so in terms of the entire field of litigation, I think it's important that we give you the heads up if we think you're headed into a tunnel and there's a bright light coming our way, or if we are going to take the offensive with someone. What are we really fighting for and why? And what is the best possible outcome, but what is a reasonable outcome too? And I think it's important that you know the range of possible results anytime you go into litigation. You need to know the good, the bad, and the probable. Very welcome.
And also, another answer to your question to us, what I appreciate about your discussions with us today is your focus on your role as a municipal attorney to provide legal advice and your limitations on providing that legal advice. There's
Right.
probably nobody in this room that has spent more time in this particular room in board meetings like I have since 2017. And I've seen, and I've always encouraged that we outsource legal experience, mainly because of the breadth of experience that they bring to the table, their background, their partners within their firm. And also they typically have more municipal law experience, which is very important to us because we've seen attorneys here, and at least I have, that don't always just stick to legal advice. They start delving into policy and even management and business kind of decisions. So, which is, I'm surprised we never got sued. But I do appreciate your approach. I appreciate the fact that your focus is there not, yes, you're there to advise us. You work for us because we appoint the attorney, but you also work for staff. But you're there for the legal end of that and restricting yourself to that legal end. So I appreciate that aspect of your interview today.
I would like to say, because I think it is tremendously important, you all have mentioned at one time or another, I think, the importance of having good relationships with staff and working closely with staff. There is a book, it's probably 30 years old now. It's called Tuesdays with Maury, and it's about somebody who's about to die and a young man who talks to him, and they kind of explore the meaning of life. I have a recurring time slot that I like to reserve for each of my municipal clients that I call either Tuesdays with Carl or Wednesdays with Carl. And that's a time for the manager to be on a virtual meeting with us, but also any of the department heads or any other staff. Normally for us in several of the boards that I represent, will have the clerk, the manager, and maybe 2 or 3 different division heads. And we kind of go around the table and we say, what have you got? You know, Bill, what have you got? And Bill will say, well, I really need this agreement back from you because all the other parties have completed it and you haven't finished your review yet, which tends to light a pretty warm fire under my backside. But also to just cultivate that easy flow of information with staff. Now, it's up to the administrator to set out guidelines for staff on how they feel comfortable with them interfacing with the attorney for the town. But I tend to like having a pretty open door policy so that if somebody, is working at 4:30 in the afternoon and suddenly goes, I really am uncomfortable with this, I wonder if I could talk to Carl. I would like them to be able to, particularly if they're working on a memo for you that's going to get put into your packet later this week. I would like them to feel comfortable in giving me a call and saying, I'm uncomfortable with what we're doing here from a legal, not a policy perspective. I'm also a real believer in short memos to capture individual issues so that you can ask those questions quickly. But I really believe, for me, the very best hour that you are likely to pay me for is the hour that's a Tuesdays with Carl or a Thursdays with Carl, because we tend to find issues and nip them in the bud quicker when we do that with staff. And it also gives us the heads up on questions that you are likely to ask us in open meeting. And there's not much that's worse than getting caught flat-footed, as you all know, in an open meeting. And I suppose the honest recourse is to say, I don't know, and you will hear me say that. And I will have to study it. That doesn't mean I'm going to spend 25 hours on it. It means I'm going to take a look at it and try to figure out how much time I should spend, talk to the administrator and figure out, what do we really need to know on this? And once you get your agenda packet, your final agenda packet, I ought to have a pretty good idea of the questions that you're going to ask. And if I don't, it's because I'm not up to speed on a particular issue, or I've done a bad job anticipating what your questions are likely to be. But I hope I won't often say to you, I don't know, and I'll have to look it up. But I might. So. And I do very much appreciate You are paying for a professional service. You are entitled to professional product. If I am rushing to get something out, it is not inconceivable that you would see a misspelled word. Usually that's because it's a word that has more than one meaning or something like that. I hope so strongly that with the word processing software that we have and now AI, that we're not going to have much of that. But I think you are perfectly justified in taking me to task and saying, this is not the product that we're looking for. You can do better. And if you call me out like that, I will not be happy, but I will acknowledge it if what you say is absolutely true.
I would do so very tactfully and not in public.
But if your role as a trustee for the town means that you need to call me out, I would expect that you would do that.
Yes.
I don't like it. I hope it never happens.
We also have a common goal of building trust, not
Yeah.
just collectively,
Yeah.
not against each other. So
I appreciate that very much.
Yes.
I truly do.
Okay. So I want to say thank you. I was also going to say thank you for your well-defined outlook on your representation as our town attorney compared to policy versus giving legal advice. That one has been huge to me as well. In this environment, I think it is exceedingly important to understand where that role lies, as we have dealt with things previously in that situation. I had the opportunity to interview over the phone, and I absolutely loved the idea that you supported town staff's involvement with like a Tuesday with Carl or a Wednesday. And I know, speaking with Patty, that is something that is exceedingly important when it comes to bouncing ideas off of our town attorney or having that availability to interact with you, whether it be through the staff choosing to go through Patty to interact with you, or staff being able to send an email saying, hey, will you look at this and give me an FYI? I liked the availability that you had, where you are available 24 hours a day, 7 days a week in an emergency situation. Now, of course, don't abuse that situation, and, recognize that if trustees have questions and reach out, that you are available within 24 hours to respond. We did interview, we had more than you as an interview prospect, and I'm going to pronounce her name inaccurate, Steffel. She was actually able to have conversation in the interview process. So that was exceedingly beneficial to have, because there was additional information there in that meeting, and the amount of education and background she has is impressive. And I think that the realization of having additional supports and having that outside attorney brings on the possibility of having multiple avenues when town staff needs it for legal advice or recommendations. You guys actually stood out because in your interview, because of the specialization that you guys had: water, municipal districts. You had metro district experience with Miss Steffel. There was a lot of information that came additionally in that interview that we don't get to hear sitting up here right now. But I would say that as far as budgetary expectations, that's laid out annually in our budget. Respecting that and understanding that if you see something coming down the pipeline, heads up, FYI, hey, this is going to take more hours than what I see projected for this kind of cost, an item like that. But that would be more, I think, of a communication towards Ms. Garcia herself and saying, hey, this is like 50 hours instead of possibly an hour or 2 hour review of something. So just making sure that those lines of communication stay open and not exceeding budgetary expectations, or if we are going to, giving town staff that heads up in the budget and understanding. I think that's a huge one to me, knowing that they can set budgets accordingly. So that one I know is laid out. The Bob's rules got answered already. I think to me, the biggest thing and expectation would be an education base on conflict of interest and how that pertains to not just the Board of Trustees, but all of our rest of our boards that are here in the town as well. I think that one has been like a huge sticking point for me. I appreciate that you realized and talked about discussing with Secretary of State if you do have to turn over an item, or the independent review committee was also an additional option. So I think those kind of that kind of information and education to all of our boards, and understanding how you would lay out, how you define or identify like members that would have possible conflicts. I think that was a big one, as well as some people may not even realize that conflict arise until you get someone with the horse is already through the barn door kind of thing. So I think that education aspect and the fact that you do provide that was another thing that was kind of a check mark on items that we didn't get a full education process on coming on, but I think that would be one of those. We got a general conflict of interest overview from, so kind of is insurance correct? So just from an insurance agency part of it, more than having that town attorney that is, there's just a relationship there where you can reach out to your town attorney and say, hey, is this a conflict? And I think that having that, not just for Board of Trustees, but also having that as you have your planning commissioners and your Board of Adjustments, for them to also be able to send a quick email, hey, can you tell me, how do I go about asking if this is a conflict of interest or not? Those kind of things are huge when it comes to keeping trust with the residents and building that transparency. Those things are expectations and something that is of importance when it comes to looking at that stuff. But no, I don't. Other than that, I think that kind of sets the standard and expectations of what I would expect from a municipal attorney, or like our board as a whole would have those one-on-one connection expectations. I think realizing that we're a smaller community and we are tight-knit, there might be that head-to-head butting, but at the end of the day, we're still representing a large community, but we're all part of that community. Right. So I like the fact, and some of the recommendations and discussions you've already discussed on realizing that, you still have to represent everybody. So I think walking into that understanding as a town attorney that you represent the whole, not a percentage of the whole, is a huge thing. So I don't have any further, really, but I thank you very much.
Thank you very much.
I want to thank you for your presentation. You did fantastic.
Thank you.
Water is such a big issue. We have, some big contracts hopefully coming due here shortly. So I'm glad we don't have to outsource it like I thought we were going to have to, that we got somebody extremely knowledgeable.
I apologize that I don't know this. I thought you had a water attorney that works for you now.
Right.
I want to make clear that we're not looking to poach anyone's legal business. So we're interested in being supportive. And it's very helpful to have clear lines of delineation. Does your water lawyer handle things like CBT allotment contracts, water court pleadings, stuff like that? It's all stuff that we do that we know. But if you've got somebody doing that, and particularly if they're doing it at a reasonable cost, that's a good thing for you to keep. And we can always speak collegially, but I would want your outside counsel in any area to have confidence that if we're your town attorney, we're not looking to poach their business.
Beautiful.
So that they feel comfortable, that they can give you tough legal advice, and that we're not going to try to get in there and insert ourselves as a wedge between that attorney with specialized knowledge and the board.
Perfect. That shows your integrity. So appreciate that. Also appreciate your knowledge on metro districts. I mean, we're going to be discussing that, or the new board will be discussing that pretty shortly, so appreciate that. I do have one other question that was not brought up.
Sure.
You work for a lot of municipalities up and down I-25. 10-1, you have worked with CDOT on overpasses and everything. What insight can you guys bring to us on that, or can you bring a lot of insight?
Um,
Or is there any insight that you can
well,
bring?
there are a few.
Mhm.
CDOT often has a planning horizon that individual communities that are affected by the decisions that they're making may not actually become very aware that there is the prospect of a new overpass or a new interchange. But a new interchange has tens of millions of dollars of impact almost immediately. And those kind of decisions. So actually having staff that has their ear to the ground with CDOT and knows what's going on I-25 or Highway 1 is awfully important. I mean, you drive through what I drove through tonight on a really regular basis. So you know how disruptive it can be. And that's in absolutely beautiful weather. So once again, I think it's about communication. I think it's about learning what decision makers at the state level are thinking, and then letting them know what you need. You know, it's not a one-way street. That should not be top-down management. It should be, these are the needs that our community has. Help us, CDOT, to meet these. And, working with all of the state agencies to let them know what you need. So if they are saying internally, do we need to run this up the pole with some of our local governments? Somebody at CDOT says, I've got a good relationship with somebody at Wellington. I ought to just give them a call and see what they think. That's gold. When that happens, that's powerful. So, cultivating those kind of relationships, I think is really good. And your local staff should not ever be intimidated by the fact that somebody is working in a 8-story high-rise in Denver and knows all kinds of federal law. They know what's going on the ground here. That's tremendously important. That's where the rubber meets the road, and they should not be afraid to say, here's what we know, and here's what we'd like you to know from us. What can you tell us that will help us do a good job for our citizens? I mean, that's the kind of conversation that we ought to be having at every level of government. But that's as much as I'll say about my outlook on policy. So
Thank you.
Well, thank you, Mr. Cumley. I'll try to answer just a couple of additional things that you had asked really quickly. And I really appreciate that you've brought up collegial relationships here a number of times tonight. I think the board over the last number of years, I think has done actually a fairly well job of working together and that sort of thing. I think over the 4 years that I've been on the board, we've had maybe 2 executive sessions, kind of ad hoc in the middle of a meeting and that sort of thing. I do want to say that most of our executive sessions are at the end of our meetings, but obviously, if it worked for your firm to move those types of things, or if that would work, whatever that might happen to work for you, especially as far as a budgetary process for the town, if we don't need you for the entire meeting type of thing, if be here at kind of midway through, and that I'm sure those things can all be hashed out. I will say I did pull the budget numbers just really quickly here as far as our admin and legislative budget basically is about $110,000 for 2026. Obviously, we'd be looking to negotiate with you as far as that goes. I will say our former attorney was actually cutting us a fairly good deal. So you've come in a little higher, but I'm sure we can discuss that a little further down the road. Let's see. obviously litigation aside as far as that number goes. And other than that, I think those were the only other missing items I had. Did you have any further questions for us?
I know day one, one of the things that I'm going to want to do early on is have someone from the town drive me around and let me know on the ground, this is such and such a development, or we had a great developer here, COVID came along, they stopped cold, we'd love to have them back. Or, here's the wastewater treatment plant, we're under capacity. We need to, our growth projections for the next 20 years are X, and we're going to need to meet or develop expansion plans. How are we going to fund it? Having an awareness on the ground for your attorney. I mean, you employ us to understand a certain set of facts, to know the law, to be able to apply the law to those facts, and to advise you. I mean, that's shorthand, that's what we're all about. But we need to know the facts. We're going to learn most of those facts from staff, but it's awfully nice to have a map, to understand the map, to understand your long-term development area, which you've probably already negotiated with a lot of your sister communities around the area. And that's important for us to know. Where you've got good relations, that's always nice to know. Where you've got bad relations, that's more important for us to know. So yeah, there's a pretty powerful learning curve on the front end that I've found. And I think there are ways to do it well, but I also don't think that that's an area. I don't want to be penny wise and pound foolish on getting grounded in your community. I think it's worth some extra time for me to learn Wellington and to have a sense of, where you want to go, what the town is going to look like in 50 years. And I'm not going to be around, unfortunately, but you all ought to have a pretty good idea of what you'd love to see. Is there going to be an administration building that has all of our offices and where the board meets separate from the library? I love the fact that you've got the library with your athletic fields. That's wicked cool. But sorry if I used a but I do think that spending time learning the community at the outset is a good investment, whether it's me or somebody else that you hire. And I would say educate us on the front end so that we can begin to provide you with real value as soon as possible.
You bet. And I think the entire community really appreciates that. And I'm sure one of us, I'd be more than happy to drive you around if you want. So, but any one of us, I think, would be here too. I will say there is an election coming up on April 7th. So two of us will not be here. And I don't know if I'll be here, but I'd still be more than happy to drive you around. So,
okay.
Other than that, other than that, I don't think I've got anything else. Is there anything else from the board before we get wrapped up here?
You can, Mr. Kimley, you're welcome to stay, or you can stay or go, but I'm going to need some direction on how you would like me to proceed. I provided you a couple options. I didn't print off my email that I sent
you're good, Ms.
Yes,
Garcia.
yes. So if you can provide me some direction on how to proceed, that would be really helpful.
You bet. There were three options that Ms. Garcia had presented. One was to go ahead and enter into contract negotiations. The second one was to, if there's any additional information we want from the firm, we can certainly ask them for that. And the final ask was if there's anything we want to revise or reissue the RFQ. I would be more than happy to say that Mr. Cumley, I think you're highly qualified. I would be glad to advise staff to enter into negotiations. If maybe we can get a thumbs up or thumbs down from the rest of the board as far as that goes. Seems good. So excellent. Well, thank you
all very, very much.
and appreciate your time tonight. So thank you.
Absolutely.
Right.
I will do one last thing. Ms. Garcia already knows this, but I host a Celtic music program on the radio in Boulder. I have for many, many years. So I'm going to wrap up here this evening by saying Mila Gurmagat gas Banachtina Fela Padrig, which is thank you very, very much and a happy St. Patrick's Day to you. So,
And you, sir.
so.
All right. With that, we'll go ahead and adjourn tonight's work session then, and appreciate everybody for being here. So thank you.